Good evening, sir.
Yeah, good evening.
Thank you for meeting with us and sharing your impressions on this seminar.
Yes.
How valuable this seminar would be for the field of arbitration, and what is your opinion on the quality of the panelists who took part in this seminar?
As far as the first question is concerned, I think it's very, very important that the education about the arbitration should spread more and more, and the universities and the younger people who have got the future in their hands are the ones who are regularly receive training or interest in it. And unfortunately, in our times there was no arbitration, because arbitration was not considered important enough. But now I think it's important, and a lot of world is moving towards arbitration. So I think it's an excellent idea. And I think the panelists were excellent. Outstanding people were chosen by you people, definitely.
And what advice would you have for the law students who wish to take up arbitration as a part of their careers?
I think many of them they should do so, because the future of litigation is not only that it's, yes, well, there are different types of litigation, but if you are interested in the commercial arbitration, then India has a huge space which is to be covered, and surely the members, young people will have to be trained and will have to learn a little more about the arbitration. They must know the international context. They must see how it works in the world. I think it will be a very good idea.
Talking about developing the law students for arbitration, what kind of skill set best suits this field?
Well, they must know the distinction between litigating in a court, where it requires different kind of skills, in the sense that even if you are, either you can argue well or you prepare well. And if you prepare, then it's a different kind of. Arbitration has a different skills, because the world of arbitration requires, for example, good reading and writing, international mentality, to be able to learn from. But otherwise, basically, it's the same in the sense that you have to keep on learning from international world, and this also is a requirement which is constantly present. Otherwise, I think it's more or less the same.
And you have been a part of the legal fraternity for a really long time now, as well as the arbitration community. So, drawing on your own experiences, what do you feel about the state of arbitration law in India today?
Oh, it's pretty bad, in the sense that the arbitration law today, the statute is not satisfactory at all. The major mistake that was made in the statute was that the arbitration was, which was meant for, in part 1 of the Arbitration Act, which was meant for international commercial arbitration. Article 1.1 of the UNCITRAL model law, which we have adopted, itself says so. But we have chosen to implement it also for domestic arbitration. And in the process, the judges are not in a position to really make a distinction, because most of the arbitration matters which they receive are domestic arbitrations. They lay down a principle which will ensure that the people will not come from abroad here. So I think there is a pretty bad position from the statute book, as well as from the court's judgment, which are highly inconsistent.
A lot of discussion today in the field of arbitration focuses on investment treaty arbitration.
Yes.
And the first investment treaty arbitral award against Republic of India has been delivered.
Yeah.
A lot of commentators have criticized this White Industries Award, while some of them have welcomed this award. What are your views on the White Industries Award, and what do you think would be the implications of this on the investment law as well as the arbitration law of our country?
Well, I think White Industries Award was only $4.1 million, so it is a small amount in terms of the kind of money which is involved in usually in these matters. But unfortunately, the White Industries Award followed two things. Several things are wrong with the White Industries Award. One of them is the fact that from Calcutta High Court, where the original award was challenged, the award which was rendered outside India, which was challenged, which was a majority award, because one of our distinguished judges, Justice Jeevan Reddy, was one of the judges, and he dissented from that particular award being given, commercial arbitration, and it was under challenge. At that time, the Bhatia principle was applicable. It was challenged by White Industries in Supreme Court. So the delay of any kind attributable to delay in the disposal of the Supreme Court matter must attribute to White Industries. Instead of White Industries doing that, what White Industries did was that it challenged the award in 2010, and then in the investment arbitration second time on the investment treaty arbitration basis, and then got an award in its favor. And in many ways the award is not satisfactory because it assumes, for example, two things. One is that it applied the Kuwait principle, Kuwait treaty principle, which is of course not applicable at all because MFN, it is true that it was dealing with MFN, but MFN is not the same thing as with India, as because you should see the whole of the principles which are involved, and it's so white industries being a small amount is not the point. The point is two things. One is that it did not, the Government of India does not choose to challenge it. Government of India does not show any reasons or public information about that subject, so that people cannot know what is going on. And thirdly, the point is that the Government of India is making a complete, Government of India is now facing, because of the 122 cancellations of the arbitration, these 2G licenses, to be involved in the challenge to 2G licenses, which runs into billions of dollars now. The claims against the Government of India runs into, already India has got 10 of the arbitrations, 10 of the potential arbitration dangers, and runs into billions of dollars. So I think the government, it's an important subject on which Government of India should seriously begin to share, or at least take the experts' advice on how to do that, how to handle these matters, which is not being done at the moment.
Certain international commentators have taken a contra view, and they have argued that host states should keep an eye on the functioning of their judiciary. So what are your views on it?
No, I don't think it's possible to do so in India at all. And first of all, the judiciary is completely independent of the executive, so no law can be passed also enacted to challenge say that the judiciary will take investment arbitration cases first. It's not possible. Secondly, I don't think it's right also, because suppose there are cases of murders, there are cases of criminal matters, criminal intellectual property matters. Just because you have a BIT, therefore they must be given a priority. I think it's fundamentally a wrong approach altogether. The Government of India must of course every effort must be made by the judiciary to quicken the process, but it cannot do anything in substitution of, and therefore it can never be set aside on the ground that there was a delay in disposal of cases.
Some newspaper reports have suggested that the Government of India has started reviewing all its BITs after this award. What do you think can be done for improving the investment law regime as a whole?
First of all, the Government of India has started to revise it or not, we don't know, because there is no way in which the public information has been conveyed to us. So there is no way to know whether if the Government of India is doing it, it must doing it secretly and privately, because I have myself tried to get information from the Secretary to the Government of India, Ministry of External Affairs, who said he is helpless, he cannot give it because it's confidential. So what is confidential about something which is public information and public? Secondly, the issue of investment treaty arbitration is becoming worse by the day, because even Australia, the white industries company is an Australian company. Australia has walked out of investment treaty arbitration being decided by its own country by a process of in the context of Trans-Pacific Partnership case, where United States is the investor in Australia. So they don't want it. Australia is facing actually serious litigation. Phillips Morris, for example. Let me give you one or two examples of this. In India itself first, the Children's Fund is a hedge fund in the United Kingdom. They made an investment in India of 1% shareholding in the Coal India Limited. Now they say, now what has happened, the Government of India has framed a regulation. The regulation is that they say that domestic coal in India must be sold to domestic consumers at a reduced rate so far as the electricity consumers, so far as they are electricity consumers, electricity manufacturers. So electricity manufacturers, so that the public gets electricity at a reasonable rate. Otherwise, if your cost is to be recovered, you will naturally have to charge higher prices. So they say that this constitutes a huge amount of loss to them, because they have, so India is expected not to make even such a regulation by which their interest is prohibited. Otherwise they say, if you make such a regulation, then we are affected, therefore you must not make such a regulation. Similarly, in Australia's case, for example, they want to they are against smoking. So they do not allow branding of the smoking. So for example, they say that it will be unbranded packets, in that the cigarettes must be sold in unbranded packets. so that so the person who, you can only distinguish yourself by saying I am Marlboro. Marlboro will be therefore sold because it's a special kind of cigarette. Because of marketing. So marketing is not permitted there. So it's in order to dissuade people from buying, they say that there must be no marking. That law was challenged on the ground by Philip Morris, which is a manufacturer of Marlboro, for example, and one of the largest of the world's cigarette companies in the United States, in Hong Kong and in Australia, saying that this is not permissible because you cannot make such a regulation because it affects our investment. And that investment was not, and the question therefore is, and there is a huge case is pending in Hong Kong High Court for that reason. So therefore, investment arbitrations, to what extent the arbitration should be acceptable. Therefore, Australia has chosen to walk out. But the question is, how long can you walk out? There are so many, and third thing is about the arbitrators themselves. Mostly the commercial arbitrators are appointed as the arbitrators in the investment arbitration also, because there are no arbitrators in the world. International arbitrators are only, it's a kind of a club, so that people who are in the club, they want the others to not come, and they want to continue in it. And therefore the result is the people who are know the public law aspect is not taken properly care account. What can India do about it? India must be aware of it. First of all, it must be greater awareness, so the suggestions will come. The model BIT of India, they have made a model BIT. India has made a model BIT just as US has made a model BIT. We have not reserved to ourselves a right to make the law that domestic laws will be applicable equally to, for example, to the foreigners. So whatever our domestic chaps suffer, they must also suffer. If you have got a domestic, if you are working in India, making investment, whatever happens applies to the domestic people will also apply to you. That position is not clear. The position is not made. Its position is made in the US laws, but not here.
Coming back to the seminar, how was your overall experience here?
Excellent. I think it's very good, very fine young people, very fine interactive sessions, and great fun.
Thank you, sir.
Thank you very much.